Good morning. Are you Autumn Payne?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
She did, Judge.
Ms. Payne, in cause number 25 DCCR 1142, you're charged with a state jail felony offense of criminal mischief from July 19th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? Speak up, please.
Yes, ma'am.
I have here on the tablet some documents that have your signature on them, but the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? So you can't change your mind if I follow the agreement.
Yes.
And it looks like the agreement is for a 5-year deferred probation. There would be a $500 fine. There would be restitution ordered in the amount of $4,050, and you would be required to follow all of the rules and conditions of probation, including having no contact or communication at all with Scott. Do you understand? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Objection, Judge.
It's admitted. Is there any evidence that Ms. Payne is not competent?
Okay.
And based on the fact that it's a state jail and you have that restitution, is there any reason not to go forward with sentencing and waive that report?
Not at all, Judge. In fact, I was going to suggest that my records only show a 2021 arrest as a juvenile for UUMV, but other than that, no other criminal history.
All right, so Ms. Payne, I'm going to find that you entered a plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. I'm going to waive the pre-sentence report, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 5 years. You are ordered to pay the $500 fine as well as restitution in the amount of $4,050. And to have obviously no contact or communication with Scott. If you do everything you're supposed to on this probation, follow all of the rules and don't have any violations, pay that restitution, then this is an excellent opportunity because you do not have a felony conviction on your record. A felony conviction on your record would change your life very negatively in lots of ways. And so this is a great opportunity. The other side of that opportunity, though, is if you violate any condition of probation, you can be brought back into court, you can be found guilty, so you would become a convicted felon, and you could go to the state jail prison for anywhere between 6 months and up to 2 years. Do you understand? Also, I want to make sure that the restitution is paid first before that fine, right? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. And so if you'll just have a seat here in the courtroom, watch for probation to call you up to her desk. She's sitting right over there, and she's going to call you up when she's ready to go over your paperwork.
Okay.
All right, good luck to you. Thank you.
Thanks.
You have Jason Weinberg. Good morning. You're Jason Weinberg.
Yes.
Weinberg. Those are those type of gym pants is not appropriate for court.
He's a jump pad.
They're not?
Oh, his slacks, Coach.
Okay. All right, good. All right. So will your client waive the formal reading of the indictment?
He does.
Find you. All right, Mr. Weinberg, in clause number 25, DCCR 1479, you're charged with a state jail felony offense of engaging in organized criminal activity, and that's from September 28th of 2025. And how do you plead to that charge?
Oh.
How do you plead to that charge? Guilty or not guilty? Sorry?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you sign these, did you go over them with Mr. Lewis?
Yes.
Do you fully understand?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement is for a 5-year deferred probation. There would be a $1,000 fine, and you would be required to follow all of the rules and conditions of probation, which would include having no contact or no communication with Corbin Rayleigh. Is it Alan?
Should be
Aiden,
eight.
Aiden Dickinson, and Jaden Chandler. Do you understand?
Yeah.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, denial of naturalization under federal law?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Weinberg's not competent?
No judge.
I think just based on the nature of this offense, I'd like to get a pre-sentence report just to see what potential conditions what might need, because based on the age and the nature of the offense. So, Mr. Weinberg, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there.
Yeah.
All right, we'll see you back at sentencing.
Thank you.
All right, sir, you're Corey Richardson. And will your client waive the formal reading of the indictment?
We do, Your Honor.
Mr. Richardson, in cause number 25 DCCR 0249, the state has elected to proceed on the lesser included offense of a Class A misdemeanor attempted solicitation of prostitution from November 21st of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And because you've done what they charged you with? Speak up.
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Crenshaw?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement is for a 2-year deferred probation. Is there a fine?
I believe there is a $500 fine on that.
I mean, it's technically it's up to the court, but I would think there would need to be a fine. If y'all want to agree to something, that's fine. If not, I would impose 500 for sure.
500's fine, Judge.
So there would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding of your agreement?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
Yes, Your Honor.
No objection.
It's admitted. Is there any evidence that Mr. Richardson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily to the lesser offense of Class A misdemeanor attempted solicitation of prostitution. Find that you entered that plea freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement and defer all proceedings for a period of 2 years. You're ordered to pay the $500 fine and to follow all of the rules and conditions of probation. If you do all of that, this is an excellent opportunity because you don't have the conviction on your record. And at the end of the probation, if you're successful, the case will be dismissed. You'll never have the conviction. The other side of that, though, is if you violate any condition of probation, you can be brought back into court, found guilty of the offense, and be sent to the Jefferson County Jail for 1 year. Do you understand?
Listen.
I'm handing you the trial court certification. This shows this was an agreement that I followed, and so you have waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's at that desk right over there, so watch for her to put it in. Okay, good luck to you, sir. Thank you.
Thank you, Judge. Thank you, Miss.
You're welcome. Last one.
Autumn Payne stood before Judge Raquel West, facing a state jail felony charge of criminal mischief, a serious offense with the power to alter the course of her life. On July 19, 2025, her actions caused enough damage to land her in a courtroom, facing consequences that would follow her for years to come. But rather than fight the charge, Payne made a choice. She entered a guilty plea, freely and voluntarily, and accepted the terms laid out by the district attorney. The agreement: 5 years of deferred probation, a $500 fine, $4,500 in restitution, and an absolute no-contact order with victim and Scott. No trial, no drawn-out legal battle. Just accountability. On paper, at least. What made this moment compelling wasn't just the plea, it was Judge West's candid message to Payne before she left that bench. The judge made it crystal clear. This deferred sentence is a lifeline, not a loophole. If Payne follows every condition, pays that restitution first, and stays away from Ann Scott, she walks away without a felony conviction on her record. But the moment she slips, one violation, one missed condition, she becomes a convicted felon, facing up to 2 years in state jail. The door swings both ways. With only a single juvenile arrest from 2021 on her record, Payne has every reason to take this second chance seriously. The judge handed her an opportunity that the justice system doesn't always offer. What she does with it is entirely up to her. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns. Because justice never gets old.